everybody's faces here, so I can still work on my computer.
All right, you've got 4:02 and you are live.
Okay, this is the May 11th meeting of the Community Advisory Board Review Committee. And I'm going to call the roll. Leonard Carson.
Here.
Dave Risberger.
Here.
Luke Murphy.
Here.
We're also joined, who else are we joined by? Do we have, I see Lieutenant Witzenberg. And I don't see Katie Butker, but I wouldn't be surprised if we see her shortly. We will be joined by the City Attorney, David Mertzig, a little bit after 5 p.m. And we have received some opinions from our DA and our city defender, which we can incorporate into some of the conversation that we'll have. Quickly, for those who are tuning in, watching this on YouTube, and maybe the very first time is Katie, the strategy for our going through this is to take the Community Advisory Board's recommendations very seriously, their intent very seriously, try to mirror as best we can that intent as we streamline language around things that are either contractually or legally requiring of such. We split the recommendations into two piles, one that required legal opinion, which we've begun to get back now, and one that we were able to tackle earlier on. We have no council members here that I see, but the structure of this is that if we do have council members in attendance, we will, before our committee begins its discussion and vote, invite the council members to provide their opinions should they have one. Meantime, I will go to our personnel director and our acting chief of police, as makes sense as we plow through these, for their opinions, which will inform ours. In the case of our being joined by David Mertzig, which again will happen a little after 5 o'clock, we will then incorporate his opinions into the pre-conversation prior to our committee having those discussions. If we find ourselves in total unanimity on the direction and rewriting as might need to happen with any of these recommendations, then great, it'll be moved forward for council. And if not, if we are not in full agreement, then we will invite the opposite opinions, the opinions on either side of the issue, to join us where they might be able to provide a little bit more substance to the argument. And then having that provided to us, we will then go back to committee and council for vote. And that's it. We are about, I think, 6 weeks into this at this point, and we're hoping that we are going to be done at deadline of a few days prior to June 1st. We're moving along. And as I sent out this agenda, again, my apologies for missing section 1, letter I, letter J, and letter L as issues that we need to, recommendations that we need to look at. I do want to do a couple of quick things. Let's first look at the minutes of these last 2 weeks, and let me entertain any changes that might need to happen with these, or a recommendation that we approve. Have we had a chance to look at these minutes from the 27th and from the 4th?
I have, Mark. They look good to me.
Okay, I saw one change that I'd like to suggest be made in the minutes of the 4th, which is in section 1, transparency and reporting and gathering information, A. This item will not move forward. Actually, this item is the first that we've identified that we're going to want to bring people back in for their opinions. Outside of that, everything else looks good to me. Anybody have any other modifications they'd like to see made? Len? Dave? No? All right.
No.
So minus that one modification that we'll make. we'll accept the minutes. All in favor? Aye.
Aye.
Dave? Yes, okay, good. Okay, so by putting together the agenda earlier in the day, I wasn't certain that we were going to receive enough information that we'd be able to continue along with our discussion of the legal concerns around recommendations. However, we have received the legal opinions from both the DEA and now from Bob Golden as well, written. So you should all, I think, have those. Does everybody have those? The opinions from Bob Golden, the defender, were forwarded from Luke to, I think, everyone. And I think I saw Len also put them out for everyone just a little while ago. So if Dave, you might be the only one who hasn't seen them.
No, yeah, I've got them. I literally opened them about a minute before we
That's
went
fine,
live.
because we'll attack them one by one in any event. So because Dave Mertzig's schedule is what it is, we will be seeing him a little after 5 o'clock, but also because we're trying to get this to a place where we have our verbiage down for everything prior to our attacking the review of proposals, Appendix 2. I had put that in here because, quite honestly, I don't want to waste any time without the legal opinion piece, which is important. Obviously, we need to go to that next. But I feel like we may have enough between the DA's opinions and also the defender's opinions to be able to get ourselves some conversation around some of these recommendations that we haven't looked at yet in the legal pile. The other piece is that there was something that was sent by the mayor, I think, to everybody on this committee, which was the City of Utica Police Department's posting of all personnel files of their officers on their website. It's not actually something that, correct me if I'm wrong, Luke, I saw any place in the CAB, but the mayor thought it was worth our looking at this. I know he also sent it to you, Lieutenant, and it features some of the opinions of a couple of the police departments involved. Specifically, the one that jumps off is that of Chief Mark Williams of the Utica Police Department. So that's up to you guys as to whether or not we want to tackle that now, or I think it's appropriate that we address it, but not necessarily something that is not part of the CAB. We can come back to it. Opinions, thoughts?
It sounds good to me, Mark. This in specifically wasn't brought up in CAB, but the idea of making information publicly available, I think it's within the lines, the spirit of the CAB. So I'm happy to tackle it and discuss it if other folks are, unless you want to continue on.
Len, Dave?
Sorry, Mark, I was trying to find the DA's, I'm trying to find the right folder.
I think the DA's comments were sent maybe along with the agenda. Does that sound right, Carrie?
Unfortunately, no, this office does not have a copy of the DA's comments.
Okay, well, give me a moment and I'll find them and I'll send them to you guys. Okay.
All right.
Oh, actually, Len, you've got them probably more handy than I do. Could you send?
Yeah, that's what I'm trying to find them.
All right. All right. So while you're doing that, though, let me go back to the question I can just ask Dave. Your opinion, is the Utica Police Department's posting of personnel files for their officers on their website something we want to bring into discussion now as if it's one of the recommendations, or are you inclined to push that back?
Well, I think I'd like to hear more of opinion on that before we make a decision on it or have a discussion about it.
Okay, and you will have seen the information from both Mark Williams and from Charles Greco. It was attached to that, but we, quite honestly, it seems clear everybody's busy, and there are some things that are coming very late in the process. So I don't believe that there's an issue. Luke, you let me know if you disagree with our just pushing that piece back to next week. I think it's something that warrants are looking at. It's something that Mayor sent to us.
Can I quickly speak to this?
Of course.
So we had a discussion with our labor attorney recently regarding this very issue. There are some interesting facts coming out of this, but one of the things that we've, and we've given this a great deal of thought and discussion, one of the things that is problematic is even with having this posted publicly, it's not going to shelter us from continued FOIL requests because as websites go, they don't get updated. So the idea that we're going to be able to put this stuff up and have it updated regularly enough so that we stay ahead of it is problematic. People are going to FOIL anyway, especially media groups that are looking pretty consistently for public information on records. And the other thing that we're seeing is we're seeing some case law now that's unfolding in regard to the FOIL requests and what disciplinary records can be put out. So I think this is really kind of an issue that with the most recent repeal of 50A and some of the goings on, we're really kind of at the cutting edge of this. And if we may be just making a lot of work for ourselves needlessly, given what our resources are. So I think this might be one to hit pause on and revisit later. That's my professional opinion.
Yeah, I'm okay with hitting pause. I'll get right with you, Katie, but not for very long. There are some questions I've got about the actual amount of physical time that might be required to be entering that type of thing, and also I do want to reconnect with the opinions of the folks at the Utica Police Department that have already enacted this. I don't have any issue with putting this on essentially pause for today, but I think it behooves us to make a connection to this, a little bit more granularly, having had a chance for everybody to kind of read the documentation that came with it and taking into account your concern as well. Katie, you were looking to get in on this.
Sure. I just wanted to mention very briefly, I mean, Chris used the phrase the 50A repeal, and I just wanted to be sure everybody was in general terms familiar with what that means and kind of why there's a little bit of trepidation and question over what we're doing. So as you may know, last year, civil rights law, section 50A was repealed. And what section 50A did was made the personnel records of any public safety worker confidential, meaning that they were not subject to any form of disclosure, they were not subject to FOIL, and that applies to police officers and firefighters throughout New York State. Otherwise, every, personnel records, even though, we like to think of them as very, highly confidential, and sometimes they are, depending on what is contained in the actual record. But for the most part, public employees, the presumption is that the information in those files belongs in the public. So what Chris mentioned was that, it was a really interesting case out of Syracuse, city of Syracuse recently, which kind of called into question parts of that repeal and the constitutionality of it. So I think when Chris is talking about a pause, it might kind of make sense to, formulate any, final policy pending the result of that case, which is presumed to be, going through the appellate courts probably pretty quickly here. But I think, again, it's just important to recognize that, this whole notion of posting publicly or even providing information that's contained in police officer and firefighter personnel files is still really new within the last 12 months. So I just wanted to be sure everybody was kind of aware of that background, especially when Chris mentions the 50A repeal. It's something that he and I and on the administrative end, we talk about with regularity, but just wanted to be sure everybody was aware about what that really meant.
Well, I'm sure I didn't, so I appreciate that, Katie. So I am going to ask the indulgence of this committee in our bringing this back maybe at the tail end of our work here for further discussion. There's some research that I think I'd like to invest in this that doesn't seem to be reflected in kind of the well, the positive reviews that we got from the Utica police on this, and I feel like, based on what Katie's saying, that there's more meat on this than it presents itself. So I think a couple of weeks to kind of digest, to do some research and to kind of digest all of the information will probably serve us well as we tackle this. Does that, so I'm not kicking the can down the road so much as I feel like we need more information than what we have. Len, Dave, I see Lucas nodding in affirmative. You agree?
No, I agree.
Okay. Very
Yeah, I'm fine with that, but I just had a question for Katie. Is this a question that you've already presented to our legal counsel?
Yes.
Okay. Is he prepared to give us a written opinion on that, or do we need that? What are you recommending?
Well, ultimately he did give us somewhat of I mean, just through an email, he did, kind of weigh in, just suggesting that it can be problematic for a variety of reasons. But what I'm generally hearing from him is that we understand and appreciate the spirit of and the intent of what we're doing here, which is, again, creating greater transparency between the agency and the community. We completely understand that. The sense I get from him is that we really should be holding off on making any final determinations about what to do with this until there's been a little bit more chance for the entire question of the constitutionality of the entire repeal to kind of process through the appellate courts, because heaven forbid we put something out, we publish something or put something out publicly that the court then rules later is an unwarranted invasion of personal privacy. It's like putting toothpaste back in the tube at that point. So I just think we want to proceed cautiously.
This kind of goes to my statement on being at the cutting edge. I think that if we put ourselves in a position, we can be putting ourselves in a libelous position without having enough evidence to show or information to back up the position is one. It's a very new thing, and I imagine that the court cases are going to unravel quickly because NYPD's done the same thing and I'm sure their union will probably at some point contest some of the information that's on there. So, and again, these things don't just happen. It takes months, sometimes longer. This is a really new approach to personnel records. And in agencies like mine, we've had an abysmal reward program or award program where people just don't get recognized for good work. So putting awards alongside discipline, I've got more awards from other agencies than I do from my own. So I think it's a little bit out of balance. I'd like to get an awards program spun up so that people would be able to see the good work that we do. But unfortunately, at this point, we don't have that balance. So there's a lot of questions here.
Right, and so also, if I understand this correctly, this affects both police officers and fire personnel.
That's correct. Yes.
Okay.
All right, so there's a lot to this, and there's a lot that is pending, that is going to be determining of what our actions might be on this in any case. So it could very well be that we look at this, have our discussion about this beyond today, and provide counsel with the recommendation that they keep an eye on the ball. Essentially, not that this gets lost, but that this is something that is going to work its way through litigation and other things, and we'll come back to it probably as we're wrapping up. All right. So again, I had put the review of proposals in the first hour of our getting together because I was concerned about losing valuable time without Dave Mertzig available. However, while we don't have any comment from either the DA or the Bob Golden on number 1I under that which we're looking for legal opinion. I have to pull up that sheet. We do have something from both of them on 1J, and 1J is, I'm going to read it. This board recommends that the Common Council and/or OPD consider adopting policy limiting OPD from using no-knock warrants for the enforcement of non-violent crimes. And if I can, I beg your indulgence on it, I'm going to read both the DA's take on that and also the defenders.
Mark, can I just interrupt you for a quick second? I'm looking through my email and I can't find the DA's email. Can you just tell me the date it was sent and I'll go through?
Okay, Len is sending that out to everybody now.
You want me to send it out again, Mark?
Yes,
I sent it.
Yeah,
Mark, I sent it to you Wednesday, the 5th when I got it.
right. Oh, okay. If you don't have it, I can find it.
No, I have it right here. I can forward. Dave, you did get it, right?
I don't believe I did. No, I got today's.
Right.
From the
Okay.
city.
To
That's-
Luke and to Dave, I do have a copy.
Let me forward it to you guys now then.
Terrific.
Sorry.
In the meantime, so
Thanks.
that's making its way to you, but I can read it for you as well. And again, for the people who are watching, it's important that they hear it too. So from the city prosecutor, okay, 1J, proposing to limit the use of no-knock warrants to violent crimes is being naive. Almost all drug cases are considered to be non-violent offenses, but oftentimes the drug dealers are armed, which makes them violent. Furthermore, no-knock warrants help preserve evidence that could otherwise be destroyed. So that's the DA's take on it, and the opinion of Bob Goulden, the city defender. No-knock warrants are important tools for law enforcement in that they protect police officers from violence and prevent the destruction of evidence. Despite the current narrative that no-knock warrants are handed out like candy, they are not issued unless, through the officer's sworn application for the warrant, they provide the judge with probable cause to believe that the subject of the warrant is armed or may confront the police with violence if notified of the police presence, or that evidence of a crime might easily be destroyed if the suspect is expecting the entry. It is the judge that decides whether a no-knock warrant is issued. They are not simply handed out for the asking. In my entire tenure as DA, I have not seen a single abuse of the request for or the use of no-knock warrant by any police force in Otsego County. And again, this came by, oh, I'm sorry, that I had these backwards. That came from the DA. I'm sorry.
Right.
Yes, I have them backwards. But in any case, so I've just marked the top of my sheet. But in any case, there's concurrence, obviously, in those opinions. Police Chief Lieutenant Witzenberg, could we get your take on this as well, please?
Yeah, this is something that we've addressed many times for the cab. No-knock search warrants are applied for in person by an officer making the application to a judge who has to then swear the affidavit. We have to provide the judge with acceptable proof that we have reason under section 690 to actually request a no-knock search warrant provision, and we actually have to request that it be executable any time of day or night. Otherwise, standard search warrants can't be executed. I believe we've got from 6 a.m. to 9 p.m. Monday through Saturday. So there has to be a provision written in, and the judge has to find that there's cause. No-knock search warrants are important. There's a myriad of reasons behind them. Destruction of critical evidence for a crime could be one of them. Safety of the officers and everyone involved would be another. And it requires a good bit of intelligence to be able to get those no-knock provisions. Intelligence by information that's verifiable.
Okay, thank you, Chief. All right, so we don't have Dave Merzick on this, but I don't know that he'd be offering an opinion that's much divergent from what we're already hearing. So I feel like we can have some conversation around this as a committee. And Luke, this, again, this is always going to come back to you. So if you can, let's get us started on this.
Yeah. So I think, this obviously is in a large part of this was in line with what happened with Breonna Taylor and the no-knock situation that went horribly wrong there, and her spouse or partner. Now it's tough because I understand that this is not a black and white issue. There's been countless times that this has been necessary, and there's been a handful of times where it hasn't. The handful of times where it hasn't has resulted in deaths, likely on the police side as well. So it's tough. I would, I'd put a call out there to the folks on this committee to hear, your thoughts on the best way going forward, because honestly, I'm not entirely sure. To be honest, and Mark, that probably isn't the answer you were looking for.
No, I'm not looking for any answer. It's just, this is coming from your committee, and we want, as we've said, to be as reflective as we possibly can of the intent of the committee, even if we wind up not able to move on something. Go ahead, Chief.
So in the Breonna Taylor incident, to the best of my knowledge, the search warrant was conducted by people that had very poor tactical training, and there was no pre-incident briefing in which, hold on just a second. There was no real pre-plan, and the officers that were conducting perimeter security were not instructed to not shoot inside of the house. And my understanding is they were actually shot from outside of the residence, which would be against every principle and pre-incident briefing that we conduct in the police department. So I think in this instance, a real lack of tactical training was identified as being one of the contributing factors. And again, goes back to one of the reasons why we do the tactical training that we do.
So can I suggest, I appreciate that, Chief. Can I suggest that the Common Council and OPD review, maybe on a yearly basis, and there aren't that many no-knock warrants, I would presume, issued over the course of a year. Review the no-knock warrants that had been issued, review the parameters of the justification of those warrants to ensure that our sense of the legal letter of the law, Lieutenant's description of kind of a shoddiness in the process in the Breonna Taylor instance led as much as anything else to the outcome that we've all seen. So just if we were able to institute some sort of regular review of the yearly, of the process on a yearly basis, just to ensure that we are comfortable that the level of expertise and professionalism and all are being followed. Obviously, that's a very wordy. It's not my recommendation, but that's kind of where I'm going with this. I feel like if there was a review policy in place for that which has happened in the last year, we might be able to identify something that we feel isn't really complying with our expectation for the issuance of those warrants. Anybody any thoughts on that? Chief, do you have any thoughts on that, actually?
No, not really. I think that's fine. We don't have very many. Matter of fact, I can't remember the last actual
Right.
no-knock warrant that we did here. And they're becoming increasingly difficult to obtain anyway. So I'm not really too concerned about that.
Go ahead, Luke.
Why are they becoming more difficult to obtain right now?
It's not the process to obtain the warrant. It's the ability for us to obtain the information. And there's a lot of reasons for that, but primarily bail reform has impacted our ability to do criminal investigations significantly.
Mark, I was just going to say that, I think this is a really good middle ground. I think it'll address the public's concern for transparency, at least the committee I was on. And given the chief's assessment that there's very few as well as decreasing number, I think this seems like a good position to take. It's just my 2 cents.
Len, you were trying to say something. You're muted, Len. Len, you're muted. And it's just us. You guys can all take your mutes off.
I wordsmith this a little bit. I have OPD annually review the PIA or post-incident analysis of all no-knock incidents for the year, along with a review of the OPD no-knock protocols or procedures.
That sounds good.
That sounds very good.
Does it say review with the council?
Didn't put that. I just said that the department would review their post-incident analysis of all no-knock incidents,
right. So I would
along with review of their department policies / procedures.
Yeah, I think that's good, Len. I think the council needs to be involved.
Yeah, I would just say it's just right after review. It just say reviewed with council, and I think the rest sounds really good.
I do too.
How would they review with council?
Well, again, we've talked about this previously, where the council will determine that somebody sits down as a their instrument essentially in that review. So I think that works.
So a council member will be.
It could be a council member, or council could say, okay, Katie, might be the person not to do that to you, Katie, but it could be Katie that is our designee to sit down and review. Go ahead, Dave.
I'm not convinced that we're achieving what we are trying to achieve with this, because number one, then you're getting into micromanagement of the council over a specific department, where that should be done with the city administrator and Katie. And once we review it once, like, do we really need to review the policy or get an update or a review of the policy every year from the police department when there are very few of these anyway? I mean, I think it's great to have a review now because of what's happened. And I think the Breonna Taylor case was a travesty of the process in that case, and well, process and everything related to that case. I disagree with removing it. I think we need to give this as an important tool for the police department that will not only save police officers' lives, it'll save the lives of people in the building that the no-knock warrant is being used on. But as far as reviewing it, I mean, maybe this is something it's an internal policy. It's reviewed within the department every year, and the city administrator is aware that this is being reviewed every year.
Yeah. So I would say
I come back to the council every year.
I would say that this is not a review of policy. I would say that this is a review of the administration of policy. And so that was the issue with the Breonna Taylor. I mean, there were a lot of issues with the Breonna Taylor incident, but the implementation of policy, that, as the chief said, if there's one of these a year, that might be a lot. But the review of the TikTok on that, essentially, to make sure that our expectation that the policy is what it is, and that the execution of that policy was. Go ahead, Dave.
Sorry, I just thought of something that might help here.
Mhm.
Every year, each department is supposed to give us a rundown of their annual report. I'm assuming that this annual report will also include any kind of continuing education classes, things like that that are being done within each department. Maybe that could just be included in the annual written report to the council.
Go ahead, Chris. Lieutenant.
I think that's a good idea. You know, we can put something in the annual report regarding that. I've got to say there's an ebb and flow to this. There seems to be in my career periods of time where we go for long periods of time where we have not a lot of at least detected serious criminal activity, but we've gone through periods where one particular person or group of people can come in and create an awful lot of work for us. So no knock search warrants, you know, we can go through 2 or 3 year period where we don't do very many of them. And then all of a sudden we have, you know, 3 or 4 that we've done in a month or two. And I think the most that we've ever done going back to the early 2000s, I think we did close to 30 of them, but that was in response to a big uptick in gang violence and crime, related crime. So there is an ebb and flow, and I think that putting that in the final report for the year would be good. You know, the other thing is that these things often, if there's problems with a particular group or individual, that may be addressed to the council or to the mayor anyway, just to let them know, because we may have to do public safety announcements even, you know, regarding some criminal behavior. So, you know, just so you're aware, it may not be just, you know, one a year. There are times where we do multiple.
So, Lieutenant, we're looking at this we're taking a long view on this, right? So this could be something that well after you're gone from the police department, we're looking at what we're institutionalizing here. I have a concern about any police department or any department or, you know, any company, any business that is going to present as part of a report, this is what we did, and without any ability of oversight to see that, in fact, the execution of, you know, all the tenets that are involved in securing a no-knock warrant had been followed and followed exactly. And this is no reflection on you, Lieutenant, at all. But for the future, having some protection against some agency, in this particular case, the police department, having them be the arbiters of what gets reported in a final document to the Common Council seems a little less transparent than I think what the Community Advisory Board was looking for. Len, go ahead.
I would like to suggest then, after the department does their annual review of all the post-incident analysis of the no-knock incidents for the year, along with review of their no-knock protocols and procedures, that the Community Solutions Board review those findings annually.
Well, yeah, and I'm good with the idea of a board. I'm wondering about how much we are putting on this Community Solutions Board. We haven't gone through the proposals yet. There may very well be a place in the scheme of things for another body. So, you know, without being specific about a board,
That's something, Mark, though, we could remove later if there ends up being another entity created to what you're suggesting. Then right. So that's something that this particular recommendation from the CAB.
I'm not sure that I understand what it is that are we looking for. We're not looking for an overview of an annual report. We're looking for like an approval body to
No,
review?
we're looking at, as we're talking specifically about this recommendation, we're looking for some level of transparency that the community, and specifically, the mindset of the folks in the community advisory board, feel that is public facing, and not having gone through a process within the department prior to its being provided to the community. And again, this is in no way, shape, or form a reflection or on the police department. I think this is just the spirit of what the CAB is talking about. And Luke, I'm out here on a limb, so if I'm out here by myself, let me know.
So you're suggesting that we have to have a third-party review of this particular protocol for the Juliana Police Department?
I'm saying that the no-knock warrant in retrospect, in a year's retrospect, annually reviewed, not something that you've got somebody, that's sitting over your shoulder and, complicating your life. But in annual review, we're able to see that the parameters that are the expectation for the issuance of a no-knock warrant have been followed as we expect that they would be.
That's what the judge is for.
Okay. But
Yeah.
again, there's what we're trying to get to is the community's connection to that transparency.
Mark?
The problem that I have with that is oftentimes so I understand what you're getting after, but these no-knock search warrants with no-knock provisions oftentimes have what amounts to secret information.
That's the thing.
So, the amount of information that could be pushed forward to an independent group will never be enough, simply because, and then we're talking about tactics, techniques, and procedures that could potentially be protected simply because if people know what our tactics are, they work to counter them all the time.
So Lieutenant,
these-
I'm sorry, Lieutenant, you know where I'm trying to go with this.
I understand where you're trying to go with it, but we're guided by case law, the Constitution, by ethical promises that we make to the judge that signs off on the warrant and to the people of the community. And while I understand what it is that you're asking for, as far as, like, I know there is potential for abuse. I get it. But oftentimes these are things that other people know about. And when you have the district attorney's office saying that in his 20-year tenure, he's never seen an abuse, I'm not sure that giving a third party, I don't even know if we could give a third party access to some of this information because it's legally protected. So I'm not really sure how that would work.
Okay. So I'm going to go to Dave. But while I've gone to Dave, and again, please, all respect to you, Chris, on this. But if you could give some thought, you understand where I'm trying to go with this, and if you can give some thought while Dave is providing his opinion as to how we might be able to get there. Go ahead, Dave.
Okay, we're talking about two things here. Correct me if I'm wrong. Putting in the annual report the number of no-knock warrants we've had for the year, and also just a blurb about the review of the procedure for no-knock warrants when they occur. Correct?
Well, I didn't know that we were reporting how many times the police department does no-knock warrants. I didn't know we.
Well, I have no problem asking for that one. I mean, there'd be some years we may not have any. Other years may have 3. I mean, there's a lot of information that goes in our annual reports from both police and fire and other departments. So I don't think there'll be any issue with that and stating that, on such and such a date, we had a review of how we do no-knock warrants, what the procedures are, and so on and so on. But I would have to agree with the lieutenant about what we can provide the public. That annual report is open to the public. Anybody can see that report. I think we're kind of jumping ahead of ourselves a little bit. I agree that it should not go, it's not something that needs to be reviewed by the group that the lieutenant is trying to put together, the Community Solutions Group. I think, Mark, what you're talking about is a group similar to what's in the index here of something that we're looking to potentially form. But even then, I don't know if that is what we're looking to do, because we haven't defined that yet.
Right.
So I think we're getting ahead of ourselves here. And I don't think it would be appropriate to then have a third party review every single no-knock warrant that's being put out there, because this is what this is the job for the judge.
Mhm. Right.
And after listening to Chris, I don't know if we could legally have any third-party group review it.
Mhm.
I mean, so
But what we
The third party group that reviews these are the defense attorneys that go in front of the judge that have all the paperwork to make sure that everything was done properly, including body camera video and video evidence from the investigation.
right,
So,
but they're in
I
a
mean, these-
sworn position, so they can
Right.
hear this. There's a liability that if they've leaked that information out, they're liable for doing such. I agree. I
Excuse me.
don't see where we can go to a third party.
All right, let me go to Len. I'm sorry, let me go to
Well-
Luke. Luke.
Well, Mark, I didn't finish.
Oh, I'm sorry. Go
I
ahead.
didn't finish. And I agree with what Len is saying and what the lieutenant is saying, but I think what we're getting at, we're talking about, let's say there's a no-knock warrant and something does happen, or people are upset about it, whatever it is, they want to have an avenue to complain about it. If that's what we're talking about, then it goes back to possibly a community policing board or something like that's in the index that we haven't even discussed yet. I mean, that would be a case where they have absolutely the right to take that complaint to a board to discuss it. But that's something we haven't even
Right. That's the
defined yet.
index. That is our last piece. So
We
I
could
want
be
to-
talking about
I
this
know,
one
well,
for a while.
you know, this is the nature of what we're working with. Luke, let me go to you. It looked to me as if you were trying to get in here a couple of times.
Honestly, I was just really talking to myself, but I think that is I think Dave hit the nail on the head. And it is difficult because it's kind of like a chicken and the egg. Which parts do we tackle in this report first?
Mhm.
I agree with both of you about this doesn't belong in the community solutions board. I think they're doing a lot, but I think this can go to in one of the appendixed boards. But I do think it's a good idea that to include them the numbers in the report, the annual report. I don't want to be that guy, but I really think this warrants discussion in terms of the appendix. I think this is an avenue that could be pursued in the appendix.
So both you and Dave are saying the same thing at this point, and I don't disagree. That we can maybe generally decide what we want this recommendation to look like, pending our review of the proposals in the appendix, which we're doing, trying to create a holistic vision of everything for having gone through it. Then we go to the proposals, and then reviewing the proposals, determine what we're going to want to do, what we're going to want to recommend, and where some of these things might lie. So I think we can do something, a sense of the recommendation, and then I can mark this to come back once we've gone through the proposals in the appendix. Does that sound about right? Dave, Len?
Well, again, I don't see how you can have a discussion about information that you're not going to be released to.
Sure enough. And I think the lieutenant has already determined a lot of the parameters of what can be seen, what can't be seen. But again, what we already know in the public record is that in specifically the Breonna Taylor case, there were procedures that weren't followed in the determination of that no-knock warrant. And that, from the Community Advisory Board's perspective, as I read it, is kind of at the heart of their wanting to make certain that we never find ourselves in that sort of a position. So there's a lot of information that we can't pull, and appropriately so. I think what we've talked about here is a yearly report that comes from, as part of the police report, that tells us how many no-knock warrants have happened and potentially, what's come of those. And then we can determine a little bit later on, as we've come through our discussion and go to the appendix, what we want, if we want to have a third party engaged in whatever fashion. And then Lieutenant, your concerns are going to inform, to a great extent, the amount of shared information that there can be, and that's totally appropriate.
Yeah, but it's not up to the police chief, whether it's Chris or somebody else. It's up to the judge. So again, I guess I'm like Dave now. I'm trying to understand what we're doing here. I have no issue with having the department review their PIAs for this particular incident, along with an annual review of their protocols/procedures. We call them SOPs, SOGs. But if the information, the particular information for those incidents cannot be released to any non-sworn officer, meaning a judge, police officers, district attorney, then what is the point of this discussion?
So the point, Len, is the transparency and what that looks like and how that's accomplished. There again, the lieutenant has already, made clear, as have you, Len, where the distinctions between what is going to have to be kept private and confidential for any number of good reasons, and what can be shared. And what we know from the Community Advisory Board's recommendation is that there's a sense, and again, Luke, if you feel like I'm misreading this, you tell me, but there's a sense that that the amount of transparency that they would like to see, that the community would like to see, is not necessarily equal to the transparency that there is now. So we're looking at this in two pieces. We're looking at this in terms of the most easily shared information, Lieutenant, which is that in your annual report, there is a section on the no-knock warrants that tells us, what's been done and, the numbers, et cetera, et cetera. And then we will come back as we look at our appendix and our proposals and determine if there's even a body that might check in on this. I'll be right with you, Dave. If this body that might check in on this, and then from that point, Lieutenant, and we'll look at legal opinion as well, what would that even look like? And will it be enough to even warrant their involvement? But I think they are almost independent discussions. Go ahead, Dave.
I think we've got some discussion drift on this topic. I think we need to look at specifically what we already have in place. The question was, do we want to allow no-knock warrants or not? And we decided, it looks like we've decided, we haven't voted on it, that we all agree that there's importance with no-knock warrants. And we've decided that we think it's fine. They need to be used as long as we include information in the annual report. And that we see that there's been a review of the rules within the police department on a yearly basis, and done. And then later on, this may come up. There's so many things. If we're looking at the appendix and making a decision on one of those groups, there could be a million things that group would be reviewing. No-knock warrants is possibly one of them. But I think if we get into that area, that discussion now, we're just going to spin our wheels on this.
I'm in totally agreement with you. Go ahead, Lieutenant.
I think into the same vein of Dave, the bottom line here is the fish rots from the head down. So if you have a police chief where you have their questions regarding the discipline of the agency, there's going to be a problem. There's potential for abuse with every stop, every encounter, every traffic stop, every interview. every encounter with the public that we have. At some point, we have to make the determination as to whether or not the police are going to be trusted or if they're going to be vilified. Yes, oversight's important, but this is why we have accreditation. This is why we have standards. This is why we have a council that the police chief has to answer to. But we can really go down a rabbit hole with thinking about the potential for abuse within an agency at every level, not just search warrants. So that's really all I have to say on that.
Absolutely, Chief, and I think we're all in agreement on that. And the last thing anybody on this committee or beyond are going to want to do is vilify the police. What we are trying to do is adhere as best as we can to the concerns of the CAB, which is our task. So I would suggest that Dave Risberger's view on this is the correct view, and that we look at verbiage along the lines of the Common Council will require OPD to provide an accounting of no-knock warrants issued in the past year in its annual report, and any other attendant information as may be warranted, not to use the word warranted, but as may make sense. I'm talking, I'm wondering if anybody else is writing. Luke, I never see you writing.
I do a lot. There's a good reason for that. I've got a few windows open. I'm just trying to keep up.
Dave, Len, thoughts on where I went with that?
So you just mentioned the report, the annual report. Is that what you're looking at? So the OPD will annually, do you want them to annually review?
No,
each
annual report that
just an annual report
states the numbers and outcomes would be lovely of no-knock warrants. We will, when we get to our appendix, when we get to the proposals per Dave's suggestion, we will be looking at these various proposals. And now we've had more of a holistic sense of what all of this is, we're probably going to be able to identify, each of us, things that if we do in fact decide to go with one of those proposals, something as a task that will inform some duties of that committee. But that's not for this particular discussion. So this is about this recommendation, and I think we can just put a period on it if we say, we're not going to say no-knock warrants, but we are going to say we want to report at the end of the year in terms of, you know, the number and other information as may be appropriate. Thoughts, Dave? Risberger?
Do you have a motion?
I'll make that my motion.
Do you have it written down? I don't have it written down. I
You see me? All right. Yeah.
When we talk about it, say it's totally different.
Yeah.
The OPD,
Go ahead.
the OPD will provide within its annual report the no-knock warrant incident data for the Common Council review.
Chief, are you good with that verbiage? The no-knock warrant data? Perfect. All right. So we've got the chief. Go ahead.
No-knock data and review process, because it's two things we're looking for here.
Yeah. Isn't the review process the review process? I mean,
well, the no-knock data is basically, I would take that as, you know, how many warrants have they had in the year.
Okay.
And then the review process is a review of the procedures.
Mm-hmm. Right. Again, though, isn't that review process for the procedures going to be the same, Chief, for every no-knock warrant? I mean, you're going to go through the same.
We are governed by Section 690 of the Criminal Procedure Law and how it is that we approach search warrants of all kinds. And we have certain provisions that we have to put in regarding specificity of the evidence sought to be seized, who it is that we're seeking to seize it from, and where specifically we intend to find it. And that all has to go to a judge, and we have to justify every element, including provisions to search the house, between 9 p.m. and 6 a.m. as well as on any day of the week. So there's a rigorous, a search warrant for an accusatory instrument for felony murder would be 1 page. Okay. A search warrant could be minimum probably 4 pages. Maximum, I've seen them go, 30 plus pages just for the affidavit. We have to fill out an affidavit prior, and then the actual search warrant giving us permission and authority by the judge to be able to present the search warrant to an individual and seize said property would be just 1 page. It would be reduced to 1 page, but the affidavit is the important part that actually gets filed with the court, and in many instances gets sealed so that people don't get to know what the contents of that affidavit are.
Right. So Chief, again, so to my point, and I think with Dave's, is this is the process. This is always the process.
This is always the process.
More expensive, or maybe, less, but that is the process essentially that need to go through to get to the point where you're going to be issued the no-knock warrant.
That's correct.
So the review of the process within the context of your yearly report is not really a part of our recommendation. It may wind up being something in review that we look at when we get into the proposals, but we're not going to tackle that right now, if at all. Go ahead, Len.
So stealing Dave's thunder a little bit, conversation drift. I actually like that one, Dave. I like that. This recommendation, its essence is that it wants to limit the OPD from using no-knock warrants. And we have drifted off into a whole new. So if we were to take the essence of this recommendation, are we in agreement that and I think Dave said this earlier, that in this particular recommendation, we are not advising to limit OPD from using no-knock warrants. That is the essence, for me, the essence of this recommendation.
Right. And for me, the essence of it, and I might be wrong, and Luke, again, I'm going to look to you, but the essence to me is that there was a concern about transparency, and at the very least that we can do is ask that there's some level of transparency in a yearly report.
Right. So we've gone above and beyond the recommendation by this entire discussion.
That's correct.
Right.
Well, I think we've completely changed it, Len, and I'm okay with that part. But I think we need to stop my stopping point is not discussing what do we do as far as if people disagree with a no-knock warrant that's happened and tying that in with something with the appendix because that we haven't decided on because we'll be here forever. I think if we're saying no, we don't agree with this recommendation, but what we are willing to do and we think is right is including a lot of information in the annual report that then can be digested on a yearly basis.
Right. So if we could, can we stop right there for this recommendation?
Absolutely.
Oh, right there. Okay.
So that's basically where we are going to stop. So we're not going to look at a review process or any other piece of that within the context of this recommendation. We're going to say that there will be an annual report provided. There is anyway, and within the context of that annual report, there will be information relative to the numbers of no-knock warrants and other attendant information as may be appropriate.
I'll second that.
Okay. Any other discussion? All in favor?
Aye.
I think so. Aye.
Okay, you had me scared, Luke. All right, so okay, Chief, I think that may be the worst of it today. All right, we're gonna hope anyway. All right, with that, our next up is section I, letter J. No, I'm sorry, that was letter J. We now have Dave Mertzig here. David, we didn't have an opinion from either our DA or defender on section 1, letter I, and I wonder if that might be something that you might be able to weigh in on. And I can read it. We can have other folks weigh in as well. Dave, if that's your preference, but let me read this out loud. So this is under recommendations requiring legal review. The board recommends that the Common Council consider implementing a formal policy that instructs OPD to make all legally released crime and arrest statistics.
Senator, for you, I'm going to interrupt my meeting, but I'm.
Len, you're
I'm the
not.
one that told him not to mute. We could use a break anyway for a second, so we'll just let Len come back. Okay, he is muted now. So, all right. So I'm going to just take that from the top quickly. This board recommends that the Common Council consider implementing a formal policy that instructs OPD to make all legally releasable crime and arrest statistics and data available and readily accessible to the public on a quarterly basis. Though information was provided by request, this board feels it would be most transparent, if OPD made all legal arrest data and statistics available to the public in an accessible manner, preferably through the Oneonta City website, paper of record, and other public places easily accessible to the community. Additionally, this board recommends that the Common Council consider the feasibility of hiring additional officers and/or OPD staff who will receive training and record keeping, ensuring a fast and reliable dissemination of information. So there's a lot going on in that. Dave Mercick, do you want to hear other opinion before you weigh in on this?
Don't care.
Okay, so what
I always have an opinion, you know.
So yes, I know. So what's your
Well, again, the answer is, and I'll defer to the chief on this, but that we already maintain crime statistics there, and he reports them to at least one, if not more, agencies already. I don't know that it would depend on how you define statistics. You know, like how many stops. I don't know what you already have in place, chief. But again, whether we post them or not, I don't know that makes any difference to the police chief, does it, chief? Because I mean, they are what they are. You already report them to the state. I don't know if you also report them to the feds.
I think, well, we do. I think we're required to report them to both for FBI and New York State reporting purposes. I think that we have, and Kerry, you might want to pipe in here a little bit. I think that we've already made some strides in identifying hyperlinks to add to our website that would bring, go ahead, Kerry.
I was pulling up the website while you were talking, but you're correct. We've also already placed a link to the FBI statistics on the police department's website. So if you go to oneonta.ny.us, you click on departments and then police, you'll be automatically brought to the FBI's Crime Data Explorer. And then that will allow you to filter down right to the municipal level. You can search for nationwide as well as statewide, county, right down to city of Oneonta.
Yeah. So again, we're already doing this. We don't need to hire special people to do that. It's already there. It's just whether the question of dissemination. Cabrc.
I was going to say, Chief, correct me if I'm mistaken. I think we've discussed this similarly in a previous recommendation, and I apologize if it's snuck in there, but this feels very familiar.
In fact, it is. I'll find the other recommendation that mirrors this, but as this has now been tailored to essentially one sentence, we're talking about OPD continuing its policy of ensuring the shared information of statistics and crime arrest statistics and data available on their website through links, et cetera, et cetera. This exists in another recommendation. Certainly, I know it does. Dave, Len, that sounds right to you as well. Yeah. So let me just do the research, go through our recommendations, find the one that matches up with this, and we can call this one done. Does that sound about right?
That's good.
All right. Do we need to vote on that?
I'll motion that.
Yeah, okay. All right, so all in favor of, I'm going to second the motion. All in favor of just finding the appropriate recommendation and consolidating? Aye.
We need to vote on that though, but okay, yes.
Yeah, I don't know if we do, but you know, I dream Robert's rules at 3 o'clock in the morning now. All right, and that takes us to number 1L, and I have to go back to another document to find that. I didn't see it in my
Mark,
legal. Yes.
if it helps you, I believe it was section 1E is the other recommendation that mirrors this one.
Okay, thank you very much. Good. That helps me a lot. Great. And I have 1L written here, and I'm not sure why. I don't see that among our legal recommendations, and I don't want to waste.
That would put up council.
No, that's
list, I
council.
think.
That's council. Okay, very good. All right, so if we can, we have Dave Mertzig here, and I feel like I don't want to. It's important that we use you when we have you to our best advantage. There's a letter on 2F that many of our recommendations are tethered to, that we can't move forward with, frankly, until we get 2F resolved. You guys are all with me on that? That's a multiple. It's 2F, and we determined that 1, 2, 3, 7, and 8, the clauses were all a part of the legal, requirement for opinion.
Yep.
That sound right to everybody?
I think so.
All right. So forgive me, but this is for the YouTube folks that they know what we're talking about. So 2F is, this board recommends that the Common Council work with OPD to review and update policies regarding use of force, specifically requiring a detailed examination of every use of force incident. This review must include a submission to the Common Council for formal review and approval prior to implementation. While this board recognizes the subject matter expertise of OPD regarding this important topic, it is important to recognize that any use of force policy must be consistent with community values. Additionally, this board feels strongly that the Common Council and OPD or any future oversight board should closely and carefully consider the following. I'm going to take these just one at a time, and then we'll deal with them uniquely. So the first of them is, all use of force policies should be written with a consistent and repeated emphasis that the legal right to use violence in the course of their job is an extraordinary privilege and responsibility, that all use of force is an option of last resort, and that police have a duty of care to all people, including people in their custody or suspected of criminal activity. This should include a clear statement that use of force should always be a last resort, meaning that officers must at all times avoid actions that might escalate a situation into one requiring use of force. Before I go to you, Dave Mertzig, I want to let the lieutenant chime in on what current policy is.
I don't have it right here in front of me, but I can tell you that use of force policy, especially use of lethal force policy, needs to be updated considering the change in law earlier this year. I have not had a chance to get to that. But our policy has been continuously updated with the most recent revisions taking place July of 2020. So we're up to date and currently in compliance with New York State requirements.
And that paragraph that I just read, which is, I would suspect, in sync with your current policies.
Use of force policy and trainings in line with current state legal requirements, which must meet approval not just by the department head, but aligned with the state laws, federal laws, and Department of Criminal Justice Services guidelines, as well as risk management specialists, which I think include our city's reciprocal insurance reciprocal to some degree.
Okay. All right. So Dave Mertzig, I want to go to you. I saw your thumbs up on that. I just want to go to you for the legal input there.
No, what I was doing was confirming with the chief that
Saying,
we correlate use of force with through our liability carrier.
mhm, okay,
I mean, again, there's nothing inherently wrong with what they're looking for. I don't know that unless we had a permanent, a permanent standing committee for review of use of force, I think that would be problematic, having the council review every use of force situation. And again, we'd have to have a pretty strict definition of what use of force was in order to determine what incidents are. Yeah, Lieutenant, you're muted. So
I'd just like to point out that all use of force incidents are governed by what we call priority of life, with the victim being prioritized over the suspect, followed by, obviously scene safety being paramount in that, to make sure that we don't have any collateral damage. But should there be an injured or wounded victim, that person takes priority over an injured or wounded suspect. So there's well-documented Supreme Court cases that rule in favor of this type of priority of life. And it is not dictated by the department policy. It's been developed through sound tactical doctrine as well as legal precedents.
Lieutenant, can I ask, how accessible is it to the public, that policy? Is that something that is easily found by the public?
Well, as the attorney that handles all of our FOIL requests is here, I think that'd probably be the best question for him.
yeah, we have talked about what SOPs. In fact, I've talked to Carrie. I haven't talked specifically with the chief, but one of the things that I would consider, I mean, part of what we're looking at is basically the lack of understanding of the folks that are addressing the concern, is that they don't understand what's already in place and the extensive evaluation and determinations that are made. This is not something that's done ad hoc on the street. And I think one of the ways to do that is to have our standard SOPs available, again, with a link on the website. There are some SOPs that cannot be disseminated because of various reasons, cooperation with other agencies, things like that. But it would seem to me that a significant majority of the SOPs, especially the ones that relate to this type of situation, we're not talking about personnel SOPs, but activity SOPs should be available and would address lots of the things that are set forth here. Now, whether or not every time that there's an incident, I just think from a practical standpoint, having a council committee to address every single use of force circumstance that arises with OPD, it would be top heavy. But again, that's something that might be considered. I just see that as difficult, and unless the council members who are doing it were already fully prepped and educated as to what the process already is and what the hierarchy of activity already is, frankly, from a defense standpoint, I don't necessarily want public discussion of every use of force incident being debated, pending a lawsuit from an individual who might believe that his rights have been violated. I think a lot of it could be addressed just showing what, and there's no problem with, don't misunderstand, I have no problem having consistent review of what our policies are. There's no, I mean, that's one of the things that you guys do, and as long as it's consistent with court cases and other issues that have both local, state, and federal implications, I mean, we're not going to say, okay, we're going to change our SOP that will put us in violation of the federal rules. So we can't do that. So I think a lot of this would be addressed by making available SOPs. That's my first step. And then after they've had an opportunity to review those, then you can go to Plan B if there are issues in the SOPs, as the chief said, if there are modifications that need to be made, because it's something that changes all the time.
So that's where I was hoping you were going to go with that, and that makes sense to me relative to number one. I think we come back based a lot on your opinion there and the overall of 2F, but relative to the subsection 1, that policies should be written and consistent, repeated emphasis, et cetera, et cetera. That's an SOP that needs to be made preeminent through its posting on the website. If the community is not aware of it, then the police are only going to be helped by the fact that they are. Yes, Chief.
I think that there's also a lot of confusion regarding standard operating procedures and guidelines. They are guidelines and they are not often followed to the letter. And I'll give you an example. The most recent use of force case that was high profile dictated that the agency, being this police department, was to be the lead investigating agency. So that said, that policy was not followed, but the law was. So, you know, there's law that dictates and overrules and supersedes policy. Sometimes policy can be written, potentially be out of date or incorrect, but law puts us in a position where we have to then follow the law rather than policy. So there's a lot of nuance here. One of the things I want to do is get looking at Lexipol, which is a way for us to keep policies more up to date. Policy writing could be an absolute 100% job for one person for an entire career. So
Exactly.
they're never gonna meet the standards that people want, and people are always just gonna go ahead and find fault because they'll never always be 100% up to date. But the law that we're following is.
Thank you, Chief. All right. So again, we have the overall of 2F, which I want to push back in favor of plowing through these subsections. And the first that we're dealing with right now is the intent of the police relative to use of force. The chief has already mentioned that there's an update that's going to happen relative to that. I've suggested, and I think Dave Mertzig has suggested, certainly linking to either the SOP or some verbiage that describes the police expectation of officer conduct around use of force would be valuable and would be in line with what the CAB was looking for. And I'm done talking on the subject, so I'm going to ask Dave. It looks like you may have an opinion. Do you, Dave Risberger? No? Len?
Were we trying to get to a point where we're wordsmithing this, since David and Chris have both weighed in on this?
Yes, and we're talking about the section 1. We will come back to the overarching paragraph, but plowing through these sections. So this one specifically is talking about use of force policy, and
Well, we heard our two experts.
yes,
Two experts told us that the policy follows the letter of the law, along with the parent organization, the department. Sorry, the Department of Division of Criminal Justice Service. Is that correct, Chris? Is that your
Department of Criminal Justice Services is the policy agent, the agency that provides a lot of policy guidance, but there's also national and state level.
So we could say something to the fact, Mark, that OPD's policies will be consistent with the letter of the law and the Division of Criminal Justice Service of New York State.
Yeah, the only thing I would add to that is relative to, I think it's important that we're referencing use of force.
Okay.
Yeah, but I like that, Len. Luke, I need to go to you on this.
Yeah, I agree, and I think that yes, I agree, and what Dave Merzik said about making the SOPs available on the website easily, that's easily accessible, I think will clear up a lot of questions, not only for in general, but many of the suggestions on this list, this particular subsection.
Very good. So Len, I see you writing and I appreciate that. If we can kick this off with regarding use of force and then roll into what you had said, and then potentially add in the posting of the SOP, I think we might have a recommendation. I'll let you take your time. Dave Mertzig, we will till about 6 o'clock on this. Do we have you for that length of time, or do we lose you earlier?
Let me see. Is this a wish expression or no? No, I'll be here.
No.
I'll be here till 6.
Extremely valuable to us.
No, thanks. No, I'll be here till 6.
Very good. Thank you.
The OPD use of force policy will be consistent with the Division of Criminal Justice Services and applicable laws. Is that where you're headed, Mark?
I would also add, and you guys will determine if that seems right to you, that SOPs, the relative SOP will be posted to the website.
I think so, Mark.
And if that winds up being your recommendation, Len, I'll be the first to motion to accept it.
Well, before I agree to that, I would just like to turn back to the two experts and ask their opinion that is there any implications, negative implications, if we post this SOP, SOG on the website? Because I thought, David, you said that, or is it Chris, that the SOG, which that's the way it was in the fire service, is what it is. It's a standard operating guideline that it's not always followed to the letter as a standard operating procedure. Was there a negative connotation to posting this SOP or SOG on our website?
Again, from my perspective, I think that with appropriate heading language, which says that the SOPs are what they are, they're guidelines, they are not the law. They're the policies as currently adopted, but can be overridden at any time by the law or by recent court decision. I do think having, and again, I'm not saying every SOP. I'm saying that things that relate to public interaction and that don't. That again, Chief, I'm not trying to step on your toes here, but I think that SOPs that relate to this topic, which is a hot topic, it would in fact bring to the attention of the public that a lot of what they're concerned about and a lot of what they're saying that they're concerned about is already covered by our SOPs, and would turn the volume down a little bit and saying, here they are, look at them. You want them changed? Come to the Common Council. We'll talk about it. We'll tell you what we can do and what we can't do. Because some of the things that people ask for emotionally simply don't work out in reality. But again, I think posting them with appropriate caveats makes the most sense. To be, you want to see what the SOPs are, there they are. Go ahead, look at them. If you want to comment on them, you want to amend them, come to the council and we'll talk about it. But not having them out there, I think, creates this kind of a response that says, don't do this, don't do this. We want to have oversight when in fact a lot of the things that they're concerned about have already been addressed by policy that our officers are obligated to do every day already.
Okay. So I will add in and will be posted on the city website. I will raise that as a motion.
Any further discussion? No. And all in favor? And Luke, do we have you in favor?
Yep. Sorry. Yes, I apologize.
Good.
And Len, thank you for
Dave, did you vote?
wordsmithing. I know it's. Thank you for taking that.
Dave Risberger, did you vote on this? Yes. So yes. Okay. Good. You're muted.
Sorry, I didn't realize I was muted. Yes.
No worries.
I-
No worries. And I just want to say to Chief, just as a point for your consideration, as we've gone through this, so many of the recommendations that are in the Community Advisory Board's package here, we have been reconfiguring to say the OPD will continue to do, will continue to implement, will continue its policy. So a lot of this is the Community Advisory Board, all good people, not knowing really everything that the OPD is doing. So this exercise is actually is valuable. We're letting people know that this isn't something they have to tell the OPD to do, because the OPD is in fact already doing it.
Yeah, and that's the beauty of accreditation.
Right.
Is the nature of the oversight from the state and the policies that are drafted and implemented by the agency at their request or direction.
That's a very good point, Chief, and I think that's something that ought to be. This is why OPD went through this long and rigorous process to get to the point of certification.
I'll say also, though, that that's the value of communication, and so this process
Exactly.
has
Yep.
a lot of value as well. And I know it's been difficult for you, Chief, and just so you know, that a lot of love there. Okay, we are at 5:34. I'm going to hopefully we'll be able to make a pretty good dent in 2F. I want to go to the second graph here. And there you are, Lynn. Okay. So number 2 within 2F is use of force policies should provide clear requirements for de-escalation before force is used, except in extraordinary circumstances, accompanied by guidance regarding de-escalation techniques. METI model policies contain literal flowcharts of an acceptable progression of tactics. OPD's current policies only include language about reasonableness and proportionality with no specifics. So Chief, I'm going to let you address that first before we talk about it.
This was number 1.
Number 2, it's 2F, and it's the second graph.
Use of force policy, clear requirements for de-escalation before force is used.
That's correct.
Flow charts and force continuums have been outdated for years and replaced with specific requirements based on case law. Flow charts are linear and have been shown to cause issues with interpretation of case law and focus on escalation, as opposed to situational demands and potential for the flow of force escalation and de-escalation, because things are not linear.
You were prepared. So I appreciate that. So with that, Dave Mertzig, do you have any opinion that you'd like to weigh in on this?
I agree 100% with Chief.
Okay. Anything further that you want to add, Dave? I didn't mean to cut you off.
No, I just, again, this kind of recommendation, which is, done in good faith, sometimes sort of presumes that the issue hasn't ever been thought about or addressed before.
Right.
And when in fact it has, and it's and as the Chief was just sort of demonstrating, goes beyond the sort of thinking that was put into this. And again, that's not to denigrate any of the work that was done or the intention behind it. But uh, I agree with the position of the chief. Let's put it that way.
All right. I'd like to make a recommendation for where we go with this, and then we'll have discussion or even a second on it. And that is basically to excise the second and third sentences in favor of just the first, just slightly modified. Use of force policies should continue to provide clear requirements for de-escalation before force is used, except in extraordinary circumstances, accompanied by guidance regarding de-escalation techniques. Chief, this is what you're doing now, am I right? So if we put a period there, I would recommend that that might be our recommendation. Any thoughts and I'll move that. If there's somebody who wants to second that, we can continue to have discussion. Len seconds it. All right, further discussion on this then? Luke?
I think that this hits the intent, ensuring that the policies are up to date, and ensuring that, you know, with the exception of the cases that are extraordinary, that force is being regulated. And I think by making that commitment, I think we make our stance clear.
Mm-hmm. All right, and Dave or Len, anything that you'd like to add to this before we vote? No, on Dave's part. Len, no. All right, in that case, the recommendation is to use just that first sentence and make it an expectation that those policies will be continued. All in favor?
Aye.
Okay, unanimous, and we move on. Thank you very much. All right, moving on to number 3 out of the 5 that we're going to be discussing here. Number 3, policies should include clear requirements to consider a person's specific characteristics, such as those mentioned in policing project guidelines, when considering whether use of force is justified. And again, Chief, I'm going to go right back to you.
Our current policies contain specific factors, including severity of crime, level of threat, immediacy of threat or resistance posed by the subject, potential for injury to the public, officers and suspects, risk of potential escape, knowledge, training, and experience of the officers and subject size, age, relative strength, skill level, injury or exhaustion of the officer, number of officers on scene, as well as other environmental or exigent circumstances. So this is something that's addressed widely in policy and procedure, as well as with case law, given there is a reasonable officer standard that all force cases have to be judged against in the courts.
Okay. So this is a standard operating procedure for the police department?
Listed in multiple places in our use of force policy.
All right. And again, so go ahead, Luke.
Yeah, and I have it up right now, and I think this was in regard to particularly one of the questions is, does the department require officers? Oops, sorry, wrong one. In the event, Chief, and I know this really isn't happened a lot here, thankfully, but is there a policy in place if, for example, an officer is found that the use of force was improper or uncalled for?
Yeah, anything that would fall outside of the approved guideline for use of force given a situation could result in retraining or disciplinary action.
I think that was the intent, Mark.
Yeah, okay, all right. Len and Dave, I need to bring you into this as well. Either of you, basically, I'm looking at a similar sort of a take on this, in that we're saying the clear requirements should continue to be provided, and the standard operating procedures should be made available to the public through a link on the website relative to person-specific characteristics, such as those mentioned in the policing, blah, blah, blah. I can restructure the sentence to make some sort of sense. Go ahead, Len.
Can we just take number 3 and say, refer to number 1? because we just reworded number 1 as the OPD use of force, SOP, SOG will be consistent with the Division of Criminal Justice Services and applicable law or laws, and will be posted on the website, city website.
Okay, Luke, this is your baby, so let us know what your thoughts are on. We wouldn't be saying C1, we would pull this out because 1 is addressing it.
Correct. But for today's discussion, we would acknowledge that the parameters or the essence of number 3 was involved in our discussion of number 1.
Right.
And it
Yeah.
seems like it would be resolved then.
Right.
Right. And Mark, I mean, this is, if I remember correctly, looking at, I'm sorry, there's a couple of bullets here. I'm just trying to find the one that was talking to. Essentially ensuring that there is, oh my goodness, my windows. I'm so sorry, folks. I lost you for a second.
You're fine.
Yeah, and I think what the chief said is in line with looking at over here the policing projects standards. So I think that sounds reasonable.
All right, then I would make the motion that we strike this in favor of consolidation to number 1. Anybody want to second that? Len seconds that. Any other discussion? No discussion. All in favor? Aye. Davies, okay, you're saying aye. Good. Freaked me out there for a minute, Dave. All right. So 7 in the 5 of these. So this is the 4th of the 5. OPD policy should extend the prohibition of use of deadly force to prevent damage or loss of property to all uses of force beyond restraint. The use of deadly force should only be justified when life is in danger. I'm going to keep my opinion to myself for a second. All right, Lieutenant.
This is covered in Article 35 of the New York State Penal Law. Deadly force may be used only in specific cases in which threat of death or serious physical injury to the officer or a third party is imminent. There's much case law regarding this topic, but there is no provision for the use of deadly physical force in a property crime.
Dave Mertzig, anything that you want to add to this bit of discussion?
And not really, the chief has accurately represented what the law is.
All right, very good, thank you. All right, so Luke, again, I'm not picking on you, but this is, you've seen all this stuff before it came to us. So this again looks like there are policies in place. There are policies that are not applicable as well. Where are you on this particular clause?
Well, it sounds like what the chief said. The statute is exactly what we're looking for. That life is only, deadly force is only used when someone's life is endangered. I like to bring this up every once in a while. The committee, all of us worked very, very hard. We all didn't have access or know necessarily where to find every single statute. So I know some of these things have been covered. I appreciate everyone's patience to discuss the things that have been. No, I think, if there's a law in the books that hits this point, then I think that's
Yeah, I believe the specific law is Tennessee v. Garner in this instance, and that would be a use of deadly physical force for an unarmed fleeing felon from a property crime.
Okay, and again, this is a policy, this is a guideline that exists and that can be made more public than it is.
Yeah, it would be included in our deadly physical force policy, but it's also federal law.
Right.
So it's not just here, it's nationally. The use of deadly physical force for property crime is an unlawful Fourth Amendment seizure.
Sure. So what my point is that we had a whole bunch of intelligent folks working on this, CAB, and they weren't aware, or they wouldn't have spent the time, building out the recommendation. So I suggest that there's an opportunity for some, public education. Okay. All right. So what do we do with this, guys? Dave, Lynn?
Does this fall in the same context of number 3? Or am I
In other
misunderstanding?
words, we strike it in favor of the more all-encompassing one, and basically what we're asking is that these, the policies that the chief knows, like he knows, air, and the same of the OPD. This is something that the community isn't even as aware of. So we provide some education to the public via the technologies that we have, internet specifically, right? And that's covered in 1. So we're going to strike it. That's the recommendation that I would have in favor of something that is more encompassing for 1. Len, you seconded that. Do we have any other discussion on this? Okay. All in favor then? Aye.
Aye.
Aye. Okay. Very good. So the last of these is the use of force is currently allowed as needed to obtain compliance. This board recommends the Common Council explore the use of force and non-compliance. This board feels non-compliance alone should not be sufficient basis for the use of this force. My accents were in the wrong place on that sentence. Let me just reread that one sentence. This board recommend the Common Council explore the use of force and non-compliance. So the idea is non-compliance and force, the policy of the OPD relative to that. Chief?
I think that maybe at this point, I'm just going to defer to the opinion of the district attorney on this. If you look, he references it specifically in his last portion.
Okay, well, let me read that then. All right, so that is 2F8, and he writes, make sure I got the right, yeah. The committee states that it feels that non-compliance alone should not be sufficient basis for use of force. Once again, a recommendation based on feeling instead of common sense and reality. If police cannot use physical force to obtain compliance from suspects, how will they get compliance? Should we just let the drunk driver refuse to be arrested, get back in his car and drive away so that maybe he can kill himself or someone else? Should we allow the operator of a motor vehicle that has been found in possession of a kilogram of heroin refuse to be arrested and re-enter his car where he may have a weapon to kill the police officer? And if he doesn't, should we just let him drive away, never to be prosecuted? If the police can't use the minimum amount of force needed to obtain compliance, then eventually there will be no compliance and the police will no longer be the police. They will simply be citizens in uniform without authority over anyone, with no ability to protect anyone. It will lead to a lawless society. This is not only ridiculous and a responsible recommendation, it is dangerous.
I would just like to comment. I find that disrespectful.
Yeah,
The committee put a
I'm
lot of
going to
time and work into it.
Bob
If I
Gould,
might
take on this.
say I don't necessarily just agree with the last portion of this, but I will say that I have written here, non-compliance needs a better definition. There's no law for non-compliance. There is for many issues that may arise to the level of a petty offense or a crime, in which case New York state law allows for reasonable and justifiable use of force to arrest a person whom probable cause exists that they've committed a crime. Any non-compliance is a criminal act specifically addressed in section 20530 of the New York State Penal Law. I think one of the things that I liked about what the district attorney cited is that there has to be some balance based on physical force for non-compliance. Non-compliance in and of itself has to have some sort of context. And I think that he lays out nicely in that the operator of a motor vehicle that's been found in possession of a large quantity of drugs or a DWI, for instance, may not be inherently violent in and of themselves, but we cannot allow people to just walk away or sit down on the pavement and wait until they finish doing whatever. There has to be at some point the ability for officers to use a reasonable amount of force necessary to effect that arrest and get somebody into custody.
I'm going to read Bob Goulden's comment on the same. He writes, if a person is refusing to comply with lawful requests of a police officer and refuses to comply with them, force may be the only option. If the police cannot obtain compliance, then we will have anarchy, which we can all agree is not acceptable. So there are two legal opinions, one a little bit more flowery than the other bit. Dave Mertzig, I wonder if you want to throw a third in.
My notes in red simply said ... just walk away ? The problem is, discussing compliance with either someone who's drunk. I mean, I'm thinking about the incidents that happens in innumerable Thursday, Friday, Saturday, and Sunday nights in downtown Oneonta. Non-compliance, either the concern would be if non-compliance occurs and there are no consequences to non-compliance. What's the consequence to simply, if a police car wants to do a traffic intervention and turns on his lights and you simply say, nope, I'm not feeling it today. I think I'll just keep driving away. I don't know if you saw the incident in the newspaper today. There was somebody who was pulled over for DWI and he simply locked the car door and sat there and refused to let the police officers in. It was the sheriff's department. And so if they're just going to leave him by the side of the road, I mean, there has to be, when there's willful non-compliance, there has to be some mechanism other than verbal saying, we really mean it, you should be compliant. And it doesn't work with 3-year-olds either, there has to be some mechanism available when there is a wrongdoer to intervene. And again, appropriate to the circumstance. It has to be something that is the least amount necessary. But there's got to be some mechanism available for compliance. And right now, force is the only one that seems to work in my vocabulary. And I think currently in the police vocabulary as well. Again, if someone else can figure out something other than that, I'm happy to consider it.
All right, Dave.
I've got a question for Luke. Luke, when the committee came up with this recommendation, the sentence that jumps out for me, the board feels non-compliance alone should not be a sufficient basis for the use of force. What was their thinking behind the statement? Like, what were their thoughts? Because it may be that what they're thinking is they're coming at it from a different direction than we are, but I'm not sure what it is, and I'm hoping you can.
Yeah. So I believe what they were coming at it from was the worry that compliance would be, or non-compliance rather, would be used as an excuse for action taken. Again, a lot of this is worst case scenario, but worst case scenario happens, and it happens more than we'd like to see it. So, for example, if someone is arrested for, I can't think of a specific example off the top of my head, but and the excuse was given, well, there wasn't compliance, and just I think there's a worry or fear of the subjectivity of compliance.
Well, what are they looking? What is the additional thing with non-compliance that would be the basis for the use of force? Was that discussed?
I'm afraid I don't know what you mean.
Well, it says this board feels non-compliance alone should not be sufficient basis for the use of force. So what additional component are they looking for that would justify the use of force?
Well, I think they were looking for. I think this was mostly in regard to some of the things that have happened. Uh, Again, outside of Oneonta, but to making sure that we're crossing our T's and dotting our I's and making sure that things don't happen. In terms of a specific, um, I'll be honest, Dave. I'm struggling to remember. I'm going through my notes right now.
All right, let me go to the lieutenant, Luke, while you're thinking.
Well, what I have written here specifically is non-compliance needs a better definition. So there's no law for non-compliance. So nobody can ever be arrested for non-compliance because it doesn't exist. There has to be some sort of precursory offense that's committed in order for us to even be able to, as far as the levels of DeBoer, first one being just a common law right to inquire, there would have to be some sort of legal justification for us to inquire for even somebody to give us their identification. Okay, so there has to be some sort of existing probable or reasonable suspicion, right, of something for us to be able to ask someone for. And there's different steps. There's 4 levels of DeBoer, one being common law right to inquire. The other one would be able to ask for specific questions of the person's intent and what they're up to. The third one would be a demand for identification, and fourth one would be a summary arrest of the person. So, that said, there is, for many other issues that may rise to the level of a petty offense or crime, in which case New York State law allows the reasonable and justifiable use of force to arrest a person for whom probable cause exists and that they've committed a crime. Any non-compliance is a criminal act specifically addressed in section 20530. So if there is a law that this person is found to have violated and there is non-compliance at that point, the non-compliance falls to what we call resisting arrest or obstruction of governmental administration. So there has to be some other event. It's non-compliance in and of itself is not criminal, because I don't even know how to, we wouldn't be asking them to do anything if there wasn't some other precipitating event like blocking traffic, obstructing a sidewalk. Yes. Go ahead, Dave.
Dave Mercy.
Yeah, I think what the committee, again, I'm projecting to the committee, but maybe Luke can enforce that, is that when there have been, in fact, illegal arrests, the justification for the illegal arrest is non-compliance.
That's what I was trying to say, Dave, and I did a poor job doing it. So
Yeah.
yes,
So
yes.
so the problem, and my problem is I can only come up with Latin phrases to describe what I'm thinking of, which is not helpful at all. Again, the presumption that they're coming at is that non-compliance is used as a justification for an illegal arrest. So what they're asking for, unfortunately, in this policy is that false justifications not be used in illegal arrests. And you and I, at least the chief and I are coming at it from saying, well, wait a minute, there is no illegal arrest, which is why we're intervening. So we can't say that we won't use non-compliance as a justification for an arrest, because it can be a justification for an arrest. And what they're looking at is after the fact, saying that illegal arrests have occurred, and they're trying to figure out a way to not allow that to be an excuse. Unfortunately, from our perspective, our not only our SOPs, but the sworn duty of every officer is not to make illegal arrests. So it's a chicken and egg thing. That's all. And we're looking at it as, well, of course we have to be able to use force in non-compliant circumstances, because that's the only way we can obtain compliance. And the people who are looking at it from the outside after the fact are saying it's being used as an excuse. So again, the answer is our policy is to never have our police officers violate the law with regard to their interactions with any citizen. And there are significant consequences for doing that. And that's one of the great things about cams, about chest cameras, is that it's demonstrating more and more and more what the actions are in particular circumstances, which helps avoid the type of illegal arrest where noncompliance is justified, because then it can be seen. I don't know if that fixes the problem, but I think at least it addresses where they were coming from.
Okay, so what I am hearing, I have another off-topic point to make, but what I'm hearing relative to this recommendation would suggest to me that this probably isn't something that even wordsmithed winds up being something that we are going to be able to hand to council, because what we're saying essentially is that thing that you shouldn't do, that's not allowed, that is not policy, don't do it. So that to me isn't something that we would bring to council. It's already the rule. So my recommendation is that we strike this particular clause. I do have something I want to add though, but not as a recommendation, but my recommendation, my motion is that we strike this clause because of the reasons that I just said. And if there's somebody who would second that, we can still have a conversation about it. Nobody will. Okay. Len will. Okay. So we have a motion that's seconded that we, because of the rationale that I just gave, that we strike this particular clause. Further discussion on this? No. All right. All in favor? Aye. Aye. Okay. So the thing I wanted to add, it's not really, it's kind of inferred in this, but it's not directly it's not directly attributed to this. It's very subjective what use of force should be in a situation where you've got noncompliance. And you've got noncompliance, it could be, what's your name? I said, what's your name? You know, I mean, we've all seen that. Some of us have experienced it. And then there's an appropriate level, which isn't that. So it's very subjective. And I don't know how you create policy around it. It's training, right? I don't know that this is something that I would say goes into the our recommendations, but I would just say that I know of instances where people have been overreacted to by anybody's measure because of what the police thought was, frustrating level of noncompliance, which could have been as simple, frankly, as I said, what's your name? So there is that piece. Again, I'm not going to recommend that we do anything with it, but I do feel like that is for any police department, for any human being who's in a position of trying to enforce the law, that becomes that's an easy route to take. Not for many, maybe not even for a majority, but for some. And I don't think that I want to leave this without saying that. Okay. All right, we've hit 6:06. Unless everybody wants to push this through, Len?
Clarity. We just finished 2.8 or 2F number 8, correct?
Yes.
And we were working on, so what happened to 5, 6, and 7?
Those were not requiring legal opinions. I think we either addressed them or we'll come back to them. I have to go back to my major sheet. There were things that were contingent upon F. And Dave Mertzik has given us his opinion on the overall, which is the 2F first paragraph. I'm not going to make Dave you replay that. I can actually pull the recording of it, and so we have that to inform a conversation around what we do with the opening paragraph to 2F. 2F is.
You'll forgive me, guys. I really got to run. I got to
Yeah,
be
no, I
somewhere
get that.
in 3 minutes.
Very
So
much, Dave.
thanks. Appreciate it.
So again, even where he can just stay here, I'm not going to make him go through it again, but I've got it. I can record it. I can play it back for us. So we have Dave's legal opinion on the opening paragraph for 2F. 2F is going to inform a lot of other recommendations that are kind of sitting in limbo. I will send you guys the most recent draft version of the language, so that we've all got that together, and that'll include highlights of those areas that we haven't gotten to, either because of legal opinion being required or because they were contingent on things that we've now, I think, heard some recommendation for, and we've actually made up our minds about. Outside of that, unless there's something that anybody else wants to bring to this, yes, Luke.
Just really quick, I just really wanted to thank, I know we're all coming at this from different angles, but really thank everybody for being so open-minded. We've been here 2 hours, gotten through quite a bit, but there's still a lot to go. And I just wanted to thank those here for being so open-minded, and really appreciate it. Disappointed that our DA isn't more open-minded, but I appreciate everyone here being so.
All right. Well, on that note, guys, enjoy what looks like it's turning into a nice night, a little chilly, but nice. And I'll see some of you guys around. Okay.
Thanks, everyone.